Okay, so good evening to all of you from ADReS Now. I am Karthik from ADReS Now. This session was scheduled to be anchored by my good friend Sundar Raman, who you may have met in a couple of the earlier sessions on the same platform. Today, his work commitments have kept him away from us. For those of you who are new to us, ADReS Now is an end-to-end technology-driven ADR platform with seamless ability to handle resolution of disputes online under both the ADReS rules of arbitration as well as otherwise. And in addition to the core activity of ADR resolution on the platform, we also want to create a knowledge and experience ecosystem. And this webinar is one step in that direction. We plan to make this a monthly feature, hopefully on the fourth Friday of every month. So please watch this space. We'll keep in touch with you, and we hope you participate in the future programs as well. Today we have two eminent professionals with us for today's discussion, Mr. Prashant Chandra and Ms. Poornima Hatti. Prashant is a much sought after ADR professional and trainer. Poornima is a vastly experienced litigating lawyer and ADR professional. She is also a partner at Samvad Partners. A very warm welcome to both of you, Prashant and Poornima.
Thank you.
Karthik.
So the agenda is for the next 30 minutes or so, we shall have a discussion on arbitrator as mediator and conciliator, and then probably throw the floor open for questions from the attendees. If I may begin with you, Poornima, just to set the context, most of our attendees are lawyers who also probably double up as arbitrators and mediators. Doubtlessly familiar with the Arbitration and Conciliation Act of 1996. Yeah. But could you give us an overview of the arbitration mechanism or the encouragement, I must say, under some of our other laws? And probably after you, Prashant, can supplement what you have to say.
Thank you, Karthik. Let me begin to say it's a pleasure to be part of this webinar. And I also see some friends among the audience who've joined in. So I also look forward to the discussion after, the conversation that Mr. Prashant and you and I have, because I think all of us are excited to be part of this space, and we have particular reason to be here, knowing how courts function as they do in India. And I strongly believe that each of us as stakeholders in the larger dispute resolution space in India have some obligation to make sure that we help improve the space towards at least efficient dispute resolution system, which is at the core of all concerns. So to your question, of course, the Arbitration and Conciliation Act refers to conciliation, which has loosely been used as a synonym for mediation, and we can sort of have a conversation about the difference between conciliation and mediation. But leaving that aside, I think increasingly there is a lot of interest in this space. And, my practice is largely corporate commercial, although we do a bit of public law. You look at the Companies Act, for instance, the new Companies Act, as we call it, although it's 2013, has a conscious reference to mediation. The NCLT rules also have a reference to mediation. Unfortunately, of course, this has not been practiced in regular ways as it ought to be. So that's something that we've been pushing with various NCLTs to say, why are you not doing it? I think we've had some success in Hyderabad, where the NCLT has just picked up people in the community, almost like an amicus and said, why don't you mediate in accordance with 442 of the Companies Act? But and I know that the Ministry of Corporate Affairs has maintained a list of mediators further to this provision. But of course, it's something that the community needs to push more towards getting that. Similarly, look at the Commercial Courts Act, right? If you don't have a pressing interim relief, mediation prior to going into the process of adjudication through courts is mandatory. Sometimes it just becomes another hoop that you jump through. But I think there is a lot of thought that was given to it as to why it was actually put there. And I think commercial disputes are ripe as anything else for mediation. And it's a conscious part of, the legislative intent to put it there. So I think we should make use of it. Even if we all want to push for urgent interim relief when we go to court, and that's sort of put aside. But I think that's another significant part of the efficiency that I referred to earlier. So that's part of it. But leaving these aside, you can it's, as everybody now knows, as part of the CPC. In terms of looking at alternate dispute resolution, have a reference to conciliation. There's also a reference, in the POSH Act, the Prevention of Sexual Harassment Act. There is a conscious reference to conciliation. Again, in my opinion, because I'm involved with a lot of those cases on a regular basis, I think there is reference comes from the labor law context. It's seen as a larger bucket of employee-related disputes. And of course, with the Industrial Disputes Act, we've seen it right from many decades ago that conciliation is part of the process for resolving industrial disputes. So, mediation is you can see right from the germination from the labor laws right up to commercial disputes and the new Companies Act. There is a wide host, of course, matrimonial laws also refer to alternate dispute resolution. Lok Adalat has been around for a long time. So various statutes actually have that. I mean, even look at the MSME Act. And I think that's an active space. And we do have clients who often say, tell us what's happening in this. And, they've been encouraged by, the concerned authorities to engage with mediation. And I think that's actually quite active and been fruitful to everybody, especially with the focus on the MSME sector, even in these times of the pandemic. So these is just to give you a flavor that it's not one or two. And, a colleague of mine actually has put down a list. Consumer Protection Act refers to it. There's a SEBI circular on arbitration. So I won't take up more time on this because obviously each of them is specialized, and I'm sure Prashant has, his own inputs. But this is the large focus, if I may say so, to sort of say, look beyond the course. And that's something that the legislative intent is really coming through these legislations.
Sure. Thank you, Poornima. I think indeed that is a topic which is probably the subject matter of a discussion in itself, right? This was just to set the context. Prashant, I think you will agree with me if I say that possibly during COVID, mediation is an idea whose time has come. It was largely used in the non-commercial context, but probably commercial mediation itself is being looked at very, very seriously these days, which means that the friends who are attending this program and many more who will probably watch a recording of this on our social media handles, I think they will appreciate that their role as arbitrator is now being heavily supplemented as mediator and conciliator as well.
Yes, Karthik, at the outset, I thank you for giving this opportunity. I am only here as an advocate who has little more experience in the field of mediation. That's all. Otherwise, I'm also equal to all of you, except that I have been little more active in the concept of mediation. As you rightly said, in a way, we have to thank this COVID or the pandemic, I would say, and the lockdown. It has given the momentum to the mediation concept. Probably earlier to March 2020, I myself said, where can this online mediation happen in India? We need to have that body language, etc. And it has to be physical mediation. But I also now agree, and I have also come to realize that physical mediation is probably not possible at least from March 15, 2020. And probably online mediation is the only way. And mediation, as you rightly said, it has gained momentum from the time when the pandemic has started. And therefore, we should acknowledge that mediation is here to stay and it is here to be there for the lifetime. We have to catch up to mediation now. We have to grow with the mediation.
I think the next phase, which we are seeing right in front of us, is some kind of institutionalization of the mediation process, even in the commercial arena.
Yes, yes, you're right. You're right. See, mediation is already becoming institutionalized. For example, the Commercial Court Act, like Poornima put it has a mediation now. So it is got a statutory flavor now. There is an act and there is a compulsory mediation now. Otherwise, in fact, mediation already has the commercial flavor in Arbitration Act.
Yes.
Probably we had not used it all these days. The first reference to mediation is under Section 30 of the Arbitration Act. But none of us knew what is that mediation and what is that conciliation. Though conciliation is the next chapter itself, part 3. We were not using it. Now 89 came, Section 89 came, CPC came. Then, we had the introduction to mediation and mediation took off from there. But actually the credit should go to the Arbitration Act because that was the one where first the concept was introduced, though it was not elaborated.
And now it looks more likely that mediation will have its own legislation.
Yes, I'm told that it is on the anvil because Supreme Court is also interested to see that Mediation Act comes soon. They had set up a committee. I'm also told that the committee has given its report, maybe in this session of the Parliament, or may not be, maybe not later than December 2020. I think we'll have an act on mediation.
Sure. So the next question is to both of you as multifaceted professionals. You're lawyers, both of you. You have done trial and appellate litigation. You represented your clients in arbitration matters besides in the courts. You are arbitrators and mediators yourselves. So for the benefit of all of us, can you, maybe we'll start with Prashant and then Poornima. Can you tell us whether you have some guiding principles at the back of your mind when you change hats from one role to the other?
Certainly. The moment you say arbitration, for a layman who may be a litigant or an outsider who is not aware of the legal concepts, he thinks that arbitrator is also a mediator. What is so big about mediation? It's the same thing. In fact, they use the word mediator very loosely to include even a middleman as a mediator. They say there is a middleman. They say, sir, mediator who has settled our dispute. It could be a broker. It could be somebody else. Technically, he is not a mediator. He has to be one who has completed his course, practiced for 15 years and undergone a course. So mediation is comparatively easier for an arbitrator as compared to a judge, I would say. A judge has his own constraints as a judge because he cannot go out of the parameters which he has been put to. He is obliged to the institution and he has to work under the institution. An arbitrator is a sort of a mechanism where is more liberal, more free, more informal as compared to a judge. As compared to arbitration, mediation is little more informal or more informal. So also conciliation. So it is not difficult for an arbitrator to switch on to become a mediator. But there is a great barrier which he has to change. He has to jump. Over the years of practice, probably he has to jump.
And what is that barrier, if I may ask?
The barrier is the principles of mediation. The principles of arbitration is something similar to court, a judge, where he has to see what is right, what is wrong, and decide on that. He has to be giving an award. So it's an adjudication finally. In a mediation, it is non-adjudicatory process. And there are various fundamental principles. You take it, for example, win-win situation, confidentiality, neutrality. These are something which is special to mediation and which is very keen for mediation. There cannot be any compromise on that. Probably as an arbitrator, these are new to him. Though arbitrator is also a neutral person and a third party, that is to say neutral place, neutral person. That's the only thing which is common to mediation. Confidentiality, unfortunately, is not there in arbitration. Both parties are involved, therefore confidentiality is not there. Whereas in mediation, the party can sit, that is to say the mediator can sit separately with each of the party, and that is provided under the rules of the mediation. So that is confidentiality. Here, the confidentiality is between the two parties only, not away from the two of them. Whereas in mediation, it is within one party and separately with other party. And the mediator is entitled to that. So this is a major difference. Confidentiality is strangely or unfortunately is not there in arbitration. This is fundamental thing.
I have a question for you, but I'll come to you probably after. Poornima, do you have anything to add to what Prashant said about changing hats and building Chinese walls in your head about these various roles?
So I think, Karthik, changing hats, if you're sitting as an arbitrator, could you then sit as a mediator in the same dispute? Is something that we can discuss at a later stage. But I think there's a very, very fundamental difference between how you would approach a dispute as a mediator and how you would approach it as an arbitrator, right? With the arbitration process, as Prashant said, it is very, very formal, and the law is key to it. And with mediation, the law necessarily, need not be the central focus. Sometimes it's relationships, it's emotions, it's about continuing business. It's a whole host of other things, right? So you're not just sitting there to say, this is a breach of contract, X amount is damages, this is what's going to happen. All of that is, of course, discussed, and, counsel are involved in mediation. But I think with mediation, you can be far more creative. And I think you can have different solutions. It could be staggered. It could be a conversation that can happen in terms of addressing the problems beyond the four corners of the law. I think that's where, the creativity of the mediator comes in. And there's much more that is on offer, which you could not have discussed in an arbitration. If you want to say, let's say there's a construction dispute, and then you could, you can't in an arbitration say, are you going to work again with each other? Would you award another contract to each other? That's completely outside. Mediation, we've had those questions asked, if he closes, in the interest of continuing relationships, would you be another, upcoming project of some sort? Or, we'll make this up there, particularly in the context of the pandemic. There are cash flow problems, a whole host of issues, force majeure, and maybe things can be made up in the next 3-4 years. This kind of conversation is just not available in an arbitration or in a court context. So,
Sure.
So I think that's where the creativity and the difference. So as a mediator, you have to come with that mindset and offer these to the parties or help them get there, while you're not forcing them to do so.
See, paradoxically, something which Prashant said is prompting this question. Paradoxically, the clarity of the rules as regards the court procedure and even arbitration, and the lack of such a rigid kind of structure in mediation, in a way, won't you say, is amenable to what Prashant was referring to as anybody who is somebody can be a mediator without formal training? That is the popular conception. Because
no, that's right. That is the popular conception. Yeah, I'm sorry to interrupt. No, I think, it is a popular conception. But I think having gone through trainings with different institutes and, sort of acting as a mediator, seeing the interest in mediation, there is a lot of expertise that comes with the training. Of course, there are books that are written about mediation. Even some things as simple as how are you going to put forth the question? How do you get the parties to come together? You're not going to act, in the lay world, in the panchayats or whatever. There is a little bit of authority that rests with the mediator sometimes. Here, there is no sort of external authority. You are trying to get parties together. And I think that in itself, how do you do? What questions do you ask? How do you treat the confidential information that is provided to you without revealing it to the other side? And in a short period of time, most mediations, even international mediations, get concluded between 2 to 3 days if you sit together. And that's not a great deal of time. So that's why we say, try it. If it fails, you can always get on with arbitration or court. So it's not like you're losing a lot of time. So there's a lot that can be done in that time. And I think the training really pushes you to get to a successful mediation. And and what kind of training, of course, we can discuss later. But I think the training is very important and helps people come forth.
Prashant, are there any accepted international norms as regards mediation training? I know we haven't reached conciliation yet. I'll just come to that in a minute.
Will you repeat, because there was some disturbance in between?
Sure. I was saying, are there any guiding international principles that determine that these are the attributes, this is the kind of training that a person must have in order to be a mediator?
Not to my knowledge. We have the rules, but there is no, as I said, the time has come for a statute now. I don't think there is any such statute which is there. So to my knowledge, only the statute has to come. We all governed by mediation rules, which is of the state, not the central rules. So the mediation, yeah, please go ahead.
So if a statute comes tomorrow, which is very likely on mediation, don't you think that it could bring in a flavor of rigidity to something which is working because it is not rigid?
It is possible. It is possible.
Depends on the content of that statute.
But finally, what you have to say is the principles of mediation. When the principles of mediation is to see a win-win situation between the two parties, probably when you keep that as your goal, then you can structure this also accordingly to your requirement as a mediator.
So we just like it is probably ignored very often. I don't want to run into the danger of doing the same thing. Can you say a few words about conciliation, please?
Conciliation is actually, you are asking me?
Yes, Prashant.
Conciliation, I would say, is the direct sister of mediation, not even the cousin. Except that, I mean, I'm talking of conciliation under Part 3 of our Arbitration and Conciliation Act. Conciliator is more is that of an expert who is an expert on the subject, who could be a conciliator. And conciliator has an additional advantage, namely he can also suggest settlement to the parties. Unlike in the case of a mediation, mediator cannot suggest. So conciliator, according to me, except for the suggestion part, and another important thing is conciliation, agreeing to agree becomes an agreement and becomes a decree under the act itself. That's another advantage of conciliation. As against the compared to mediation, you have to go back to the court. If it is post-court, that is to say post-litigation, it has to go back to the court, and there it has to be confirmed by the court. Till such time, the agreement is only a formal agreement and the court will give a decree. Whereas in a conciliation, under the act itself, under section 74, it becomes a decree if the both parties agree. So agreeing to agree is possible in conciliation. Agreeing to partly agree is also possible. Agreeing to respectfully disagree is also possible in conciliation. That's also conciliation.
See, one practical example is in the field of labor law, where the same person acts as conciliator and adjudicator at some levels, right?
Yes.
So if you were to take a cue from that, well recognized practice, it's institutionalized, what would you say would be the traits that a person must keep aside when he is moving away from being an adjudicator to a conciliator and back to an adjudicator?
No, that I wouldn't endorse, because a conciliator is different from that of an adjudicator. Something similar to adjudicator is similar to arbitration. When it comes to arbitration, my opponent, as an advocate, I'm saying, my opponent's demerits are my merits. I look upon his demerits to strengthen my case. In a mediation or a conciliation, I look upon his merits to see how we can resolve it. This is a major difference, because adjudication or arbitrator looks upon the rights and wrongs of the parties, whereas conciliation or mediation looks upon the interest of the parties, the general common interest, the personal interest of the parties. Therefore, the exact focus is different in respect of. So one man wearing two hats, changing the hat now and again coming back to the same hat is not advisable.
Okay.
There is no privacy involved, confidentiality is involved in arbitration or adjudication.
Sure. Poornima, can you hear us? Poornima?
Yes, I can hear you.
Did you have anything to add to what Prashant was saying?
So I just want to point on, when you refer to the international structure on mediation, the Singapore International Convention on Mediation is coming to, sort of India has also indicated that it will ratify it. Legislation is also being given an emphasis because the largest country in the convention. I think about 46 countries have signed it already, and I think it was adopted by the UN General Assembly in 2018. Now, the idea for the Singapore Convention is that it will be similar to the New York Convention. So in terms of enforcement of international mediated settlement, you don't have to then put it as an arbitral award to have the enforcement. So while there are no sort of guidance in terms of training, it does provide the same sort of framework internationally for enforcement. So I just want to make that point on the Singapore Convention and how that's pushing here. And I agree with Prashant. I think what you do as an adjudicator is very different what you do as a mediator or a conciliator. While a conciliator does have the additional power to offer a little more sort of closer, push parties towards a settlement, which true mediation doesn't allow. I don't think that it is right for the same person to act as a mediator as well as or a conciliator and an adjudicator, because you may be given information in confidence. You may be given information in a certain role. Now you have that information. It's easy not to forget that. And how then would you sort of act? And if you have sort of indicated a certain position as conciliation to the parties, you may not have, the parties may expect you to act in that manner, which is an adjudicator or an arbitrator puts you with, because you have to then act within the four corners of the law. So I think it's best not for the same person to act in both roles, even though you may see contracts which have a ab med ab clause. But I think there should be clearly a different person coming in with each role.
Sure. Poornima, I think there's some bandwidth issue at your end. Can you switch off the video and keep the audio on so that we don't miss you entirely? Thank you.
Sure.
So one question before we probably have a few questions from the attendees. The question I had to you, Prashant. See, in an arbitration, the parties' expectations are pretty much set. They know what they are getting into. But as far as mediation go, then how is the expectation of parties managed?
See, the first thing is when they come to mediation, they come with an open mind. There is no expectation at all. They need not have to settle. They come with an open mind, with the flexibility that they can either agree to agree or agree to disagree and go out. That itself is a flexibility which I have, which means they can walk in and walk out without any commitment. That is not there in arbitration.
Is the open mind? Sorry, please go ahead.
Proceed.
I was going to ask, is open mind of both parties the ideal situation, or you very often encounter that one of them has made up their minds not to really move forward?
True, but in what happens in mediation is we usually start a mediation with an introduction of the mediation and the concepts of mediation. We call it as an opening statement. That makes the difference. In an arbitrator will not do that opening statement. In a mediation, he will explain the entire process, and he also offers them saying that what is the role of a mediator, what is that their parties can get out of this, what is the minimum expectation, all that is explained. So they are relaxed. They are not here to commit. Just because they are participating in mediation doesn't mean that they have to agree at a settlement. They can also walk out. It's like, I go into a showroom, maybe a clothes showroom, and I also have the liberty to walk out without even purchasing it. If I were to commit and say that I have to definitely buy, then I may not even walk into the showroom. So I have the freedom to go in, put 1 hour there, look at the cloth, and come back and say, thank you very much. I'll come next time. Similar is the situation in mediation. So you can walk in and walk out without any commitment. That itself is a big paradigm shift from arbitration.
So when we are hearing more and more news about the push towards mediation, where either the Supreme Court or even the RBI, for example, or any other regulator may say, you first attempt mediation and then you move on to formal processes. To some extent, don't you think that this open mind concept is getting a little affected?
I don't think, at least to the commercial world. Maybe in certain cases where egos are involved, particularly in family disputes, particularly in matrimonial disputes, yes, I agree, you may be right. But in commercial matters, since you are all dealing with people who are also in commercial field, they are open to mediation because there is flexibility available to them. Ego is very less in commercial matter. Maybe if it was between the ex-manager and the ex-counterpart. Now he has gone, he is either transferred or shifted, and the new man has come because 3-4 years down the line. So they may not have the same ego issues. The ego is gone. Only they are looking at the commercial interest of the parties. So I think the present push towards mediation, particularly for commercial matters, is a game changer.
So at this point of time, we would invite questions from the attendees. If you have any question, I think you can unmute yourself or maybe raise your hand and then ask the question either to Poornima or Prashant or both of them. Or you could even type up your question in the chat window and we could read out those questions to the panelists. While you probably think about that, I had another question. Feel free to interrupt me and ask questions in any case.
Sorry, could I ask a question?
No, please go ahead, Mr. Gautam.
Yeah. Hi. So I practice primarily as a litigator in Delhi, and this entire concept of mediation conciliation is slightly new to me. I had a couple of basic questions, perhaps. One, both of you mentioned that you don't sort of force a settlement on parties in mediation. So what exactly do you get as the outcome of the mediation process? That's question number one. And question number two is, do you sort of, from your experience, what percentage of parties who come to you sort of then move ahead and say, listen, this is not working for me and I would like to do this through litigation or arbitration? Do you have a sort of fix on numbers on that? And, I'm happy for anyone to answer that question. Thank you.
Poornima? Because I could not hear most of the part of the question. Poornima, will you answer that?
No, I think his Gautam's basic question, Prashant, was in your experience, correct me, Gautam, if I'm paraphrasing you incorrectly, right? His question was, as
Yes.
your experience, you said that you will not force any solution upon the parties as a mediator.
Yes.
Right? But in what portion of the cases do you think that the parties will to go with that open mind or otherwise? Gautam, please pitch in if you think you want to supplement.
Yeah, no, so I think that's broadly right. I just wanted to know, as in, so you said you don't force a settlement on parties in mediation. So suppose the mediation is successful, what actually happens? Do the parties then, because if there isn't a settlement, what does the final outcome look like?
Okay, the question is, what are the advantages the parties get by mediation? And if it is not compulsory on them, the settlement is not compulsory, why will they come to mediation?
Correct.
I've understood the question. See, what happens is in the court, in an adjudicatory process, it's either win or lose. Only two things possible, either 0 or 100. There is no in-between in court process. If you have filed a case for recovery of money, say 5 lakh rupees, so either the party gets 5 lakh rupees or it doesn't get anything. So 0 or 100. Whereas in mediation, the settlement could be anything from 0 to 5 lakh, 0 to 100. So the variety of solutions which he gets, also the possibility that he can also still retain the relationship, maintain the relationship and go ahead, that's also a plus point for him. So when it comes to mediation, as I said, the opening statement which the mediator makes is very important. When the party realizes, oh, this is all in mediation, the mediator is not a judge, mediator is not an arbitrator, mediator is only a facilitator, and he only facilitates, and it is me who is taking the decision. So the decision in mediation is that of the parties. Whereas in a court or arbitration, the decision is that of an arbitrator or a judge. So that is a difference. When he takes the call, he decides what is right for me. So he will say, okay, today I am, as against getting 5 lakh from the court, I have a very strong case. I have a recovery chance of 5 lakh, but that's going to be only in 2023. Is it better to agree for 3 lakh, which is being offered, which is going to come tomorrow morning? So he values that, weighs that. So 3 lakh 2020 as against 5 lakh in 2023. So he is able to take the decision. So we as mediators only facilitate, and he realizes 3 lakh today is much better than hoping to get 5 lakh in 2023. That's the reason why he would agree to settle. Hope I've answered his question. These are the facilitations which the mediator makes without he suggesting to the parties. I think Pankaj also has a question.
Yeah.
Can I just supplement that
Yeah.
question? Sorry to interrupt. So I think one other role is that we have seen that counsel also have an important role to play here, right? And I've seen that when both sides have counsel who are truly coming with an open mind mediation or have experienced mediation, there's a higher success of mediation. And counsel play an equally important role in educating their client to say, truly try this out. And we've had this in the pandemic situation where courts are not functioning to their highest optimum capacity. And there is also the risk of going to court. So, we've suggested to clients, while we wait, why don't you try mediation? And, through online dispute resolution, I think that's something that has worked. So I think that's the other way. While there is everything that is element is about consent of parties, as practicing lawyers, we also play the role of educating and, informing parties, say, look, this is an option, try it out. It doesn't mean that your case is less stronger if you go through the mediation process.
Sure. Poornima, Neelmani Gandhi had a question for you on the mediation process under the MSME law. And her question is, how would you like to guide taking forward the mediation process with MSMEs in particular? So can you throw some light on the mediation process to whatever extent it is being practiced in the MSME space? Because I suppose maybe the context to her question is also the stress and distress that that particular sector is facing today.
So you're right, Karthik, that the MSME sector has been a stress right now, and generally, the MSME sector has issues about cash flow and things like that. That's what we hear largely from our MSME clients. So under the Act itself, there is a reference of disputes to a facilitation council. So what the MSME Act is a sort of tiered dispute resolution process, and where they first try through the facilitation council, and they call it conciliation. But we've seen emails where the facilitation council refers to it as mediation, where there is already a mediator who's appointed, and you get to come and participate in that process. And I think they are fairly active. They give you a strict timeline, and it works well. And of course, if you feel that you don't want that mediator for a particular reason, you can choose somebody else. And I think they try and do as much as it without actually physical hearings, so that they get what it is. And these are usually payment disputes, vendor disputes. So it's not like you actually need evidence to be led, or in that sense, they're mostly recovery issues. And I think it's working fairly well from what I've seen. So definitely better than, getting tied up in a civil suit in court, or, trying to enforce an arbitration award later.
Sure. The only gap which I have personally seen, and this may be limited to my personal experience representing some of these MSMEs, is their e-samadhan mechanism is limited to micro and small, but they turn away the medium enterprises from the e-samadhan process. So I don't know whether the new push towards mediation will address that particular gap.
I've actually seen both sides, Karthik. I've seen even, not only micro, but even fairly medium-sized disputes, which would have been actually a chunky dispute if they went to court, being resolved through the mediation process. And again, there is the push to go through that process, sort of not entirely party autonomy, sort of ticking the box. But I think it's worked, and there is some structure and there is some respect for the process, and it has worked.
Okay. I think.
Karthik, I want to elaborate a little bit. Would you allow me to ask a little bit more?
Can I just take a question from Mr. Sanjeev Nirvani and then come back to you?
Neil, my question left half. Poornima, I just wanted some clarification on the earlier question. Shall I?
Yeah, okay, please go ahead. Yeah.
Poornima, I was asking about MSMEs. So when just now Karthik had asked, I just have to get more enlightened about when MSMEs mediator are appointed by government, Ministry of MSME. Few industries, they don't know how to go to and how to avail all these facilities. In such case, in this context, I was asking you, how would you like to guide about that MSMEs will approach these mediators, or mediators have to approach, or how do they go and get involved into mediation process?
So your question is, you want to act as a mediator in that process?
I am
or if
working
you have a
as a
dispute.
mediator. Yeah, I'm
Right.
working as a mediator since 2009. But then many of the industries, when I ask them to work or when they come to me, they say, we being MSMEs, we have to go approach the mediators appointed by government. But this list, they are not available. I just felt that these MSMEs should have easy access to the mediators. And that is
Okay.
not happening. That's what is
I
my
see.
concern.
Okay. I haven't mediated with the MSME council, so I wouldn't have any personal experience there, but I will definitely come back to you. I'll take your email from Karthik, and if you have any inputs, I will write to you. Prashant, if he has any experience, of course, can.
Me and Prashant, go Prashant, go ahead.
No, I have not had a question insofar as MSME is concerned, so I do not know about how they function as mediation there. So I do not know. Yeah.
I think if I may add, I think if this is a very appropriate topic for the MSME associations,
Okay,
right, to lobby for and say that this is the time when the processes need to be made clear and easy for this whole big chunk of the industry, right?
okay.
So
Thank
that
you.
is something which probably they should take up on a proactive basis. Right. So, Mr. Sanjeev Nirvani had a question. Can you please?
Yes, I am a lawyer enrolled in 1991. I am a trained mediator as well, and a empaneled arbitrator also. And I've seen all facets of arbitration as well as mediation. It's not exactly a question, but my observation for mediation is that it will keep failing until and unless we have a law making mediation executable. I personally have dealt two cases in mediation where the parties agreed before the mediator. There was a mediation settlement as well. And before, when the matter went before the court, one of the parties backed out. So the whole time of mediation was wasted. And we don't have any law, any rule, or any regulation to make the parties comply with the agreed settlement, which is signed also in presence of a neutral mediator.
Prashant, do you want to take that question first?
I would agree to disagree with him. I would say, I would personally, if you ask me, I would prefer there should be no law on mediation. The present rules are enough. Because the very beauty of mediation is that he can decide what he wants. He is right. We may be wrong. Time is wasted. Our efforts are wasted. It's okay. It's a service which is rendered. It is up to him to take it or not to take it. I gave the example of a cloth showroom. I may go and try to buy, and I may in the process draw about 150 items out of that and say, okay, tomorrow I'll come back. But there is also a possibility that I may go back and pick one out of that. Today I have come out because I didn't have the money, but I liked some item. Tomorrow I may go back and say that, please give me that one which you showed me yesterday. I want to buy it. That's exactly his mediation. Mediation can never fail. The efforts may fail, attempts may fail. Mediation can never fail. So it is better that the parties have a freedom to walk out. That freedom itself is a compulsion indirectly, which makes them to come back. When they compare with court, they say, okay, mediation is far better than the court. Therefore, I'll go back to mediation again. So sometimes I've seen what has not settled in mediation has actually settled in the court later, immediately. The moment it goes back to the court, he says, no, sir, we had agreed in the mediation, we would like to go by it. That is because he sees the difference between the two. So let us not go by the statistics. And sometimes the statistics may be that, it is not successful in mediation, but it is successful afterwards because in the court he realizes and agrees to the mediated settlement.
So the only point there, Prashant, is if I think Mr. Sanjeev's point was if there is an agreed settlement,
yes,
which the parties have executed, and then one of them backtracks, then won't that affect the credibility of the process itself?
Partly right, because now there are some judgments on that. By virtue of that agreed settlement, if something has already happened where the parties have exchanged something before it goes to the court, and the court says, are you agreeing for the settlement? At the time, if he withdraws, sometimes the benefits which are passed subsequent to the settlement before the confirmation, he is right. If it is not settled, even in the, if it is not agreed in the mediation, sometimes he goes to the court. That time he say, okay, I would like to go by the agreement, mediation agreement, because he sees the difference between adjudication and settlement, and he agrees, okay, today it is better to me that I get 3 lakh because I have my daughter's marriage day of tomorrow. I would like to take 3 lakhs as against wishfully hoping for 5 lakhs in the 2023. So that flexibility is required, according to me. That freedom is required for the party, so that he knows when to agree, when not to agree. Finally, he's the boss. He's the boss of his game.
Sure. Mr. Jagmohan Sharma had a question. Sir, would you like to ask Poornima your question? I think you also had a comment about MSME conciliation process. I think he's typed his question here. Let me try and read that out. Mr. The resolution of disputes clause included conciliation as a precursor to arbitration. But since both the parties to the dispute used to come with a predetermined mind, conciliation always failed. He's talking from his experience in a PSU. So in this kind of framework, how would you take forward the mediation and conciliation process is the question. I think it goes back to what Prashant was talking about, parties coming to the mediation table or process with an open mind. But if one of them has come with a predetermined set of views, then I don't know whether much can be done. Of course, a skilled mediator could bring that person round too and make the person see some sense in moving forward with the settlement. But I leave it to you, Prashant, to answer that.
No, I agree. As I said, open mind and the opening statement, which is very important. He may have come with some prejudiced mind, according to me, but I should not, as a mediator, I should never think that he has come with a prejudiced mind. If you sit with him in private and talk to him and know what exactly is the reason why he's not agreeing, probably then, he will understand that mediation is also going to help him. So participating in mediation is also advantageous to him. It's all where the personality of the mediator is important. The mediator as a person with qualities required of a mediator, I think he can be able to persuade and make the turnaround in the mind of the party. That also is important. Mediation, the personality of the mediator is also very important. That would be the difference.
Can I, Karthik, go back to the earlier question on, about, the mindset and enforcement? I think even with court annexed mediation, and those of you who've been to court annexed mediation, you get a wide variety of mediators who are also overburdened, and they have to sort things out in the same way. Whereas in a private mediation, we get like a whole day, quiet time, better facilities, and more sort of interested parties. Even with court annexed mediation, we still have in India above 70% in terms of enforcement and compliance. So I think there are enough studies done to say that if you are part of the decision-making process, parties tend to abide by that decision because you truly believed why you got there, and you sort of walked the talk, as opposed to a decision that is being imposed upon you, whether in accordance with law, with reason, and all of that. But it is obviously through the arbitration or through the court process, you don't have a choice to say whether I'll pay 1 rupee more or take 1 rupee less, or can I pay it in installments or whatever else. It is given to you, you have to take it. I think that process in itself has some empowerment, and that's the reason why a lot of people feel that this is accepted and takes forward the process.
Sure. Poornima, I had a question for you. Under the Arbitration Act, the disclosure requirements for an arbitrator are laid down in the relevant schedule. Would you say that for a mediator, the disclosure requirements are of the same order, or would they in fact be higher, given the trust quotient that the mediator needs to build?
I think for mediation, go forward, the trust quotient has to be very high. And I think, prior to these amendments to the Arbitration Act in the 5th schedule, which really means to show that you are independent and impartial, is really, so there should be no room to doubt you either as an arbitrator or mediator in terms of whether you're weighing in on something more so. And I haven't actually thought about it from the difference between arbitrator and mediator, but it is possible as a mediator, you may actually offer different solutions, and you don't want to have any taint to your suggestion later on. So you must hold yourself to a very high degree of sort of compliance, and the IBA guidelines, which sort of have the route in which this sort of law was placed, has this traffic light system of red, orange, and green, red, amber, and green. So you should make sure you disclose whatever you feel necessity to disclose. And, obviously parties can choose to waive that and say, we still continue with you if it is something that can be waived. Otherwise, best not to accept it.
Sure. Prashant, any thoughts?
In the beginning itself, I said that the one common factor between an arbitrator and a mediator is the neutral person, neutral place. So the same yardstick which is there for an arbitrator is good enough for a mediator.
Okay.
The only common factor is this. Otherwise, mediation and arbitration, the principles are totally different. Neutrality is very important. Neutrality check required for arbitrator is the same as the third of a mediator.
So, Prashant, recently the Bar Council of India has made it mandatory for mediation training to be given in both the 3-year and 5-year law programs.
Correct.
So, in the future, we are going to have trained, hopefully well-trained young people coming out of these colleges who know a lot more about mediation than probably our generation, which was learning on the job, right? But what about the thousands of lawyers already there in the field? How do you think mediation training can be given on scale?
Mediation actually is also being given to the lawyers. Now, as of now, there are mediators who have completed 15 years of practice who are being given training. Of course, they are picked by the judiciary. Each judiciary, that is to say, each district or taluka, they go in, and the judges from there, they pick some of the lawyers whom they have known very well, who have the qualities of becoming a good mediator. Such people are sent for training. So only requirement is 15 years of minimum practice and then training, 40 hours of training. That's compulsory.
Okay. Okay.
So up to 15 years after coming to profession, they have to wait. In fact, they are trying to reduce it from 15 to 10. But anyway, the waiting period is there, whether 10 or 15. The law is, the rule is today it is 15 years waiting, minimum 15 years. So the lawyers are also being trained as mediators.
Sure. Sure. Poornima, one question from my side to you. So far, whatever we have discussed about mediation, conciliation, and arbitration, what do you think is the impact of all these systems going online as compared to the offline world? Are there any challenges? Are there any conveniences? Any tricky areas to be negotiated? Because the systems will probably move online, just like ADReS has already done that to a large extent.
So before I answer that question, Karthik, I also wanted to make a comment on the PSU question that was raised. I think where I have struggled with mediation is with government entities, and disputes with the government. They even tell you simply off the record. There is no one officer who can take it to close this because they don't want somebody else questioning why you closed this at 5 crores. You could have closed the 3 crores. So they would rather have a court or award given to them, which they have to accept, as opposed to later on somebody questioning them as to what is the basis of this, even though the mediated process may be faster. So there is hesitation, and I think that may sort of come through with the PSU mindset in some ways. So I don't know whether the person who asked the question may have felt that. But I truly feel that when I work with the government on the other side, even in commercial dispute, they'd rather go through the motions of arbitration, get lesser award rather than get a better mediated settlement because of the structure and the way our government functions. That's point one. In terms of going online, I think recently the Andhra Pradesh High Court in a ICC award, where one of the parties was a Korean party, has clearly given effect to an international arbitration award, which is entirely done online, and the award has been well on its way towards enforcement. So I think courts are accepting that is a process, and this was sort of started well before the pandemic. So there's no worry in terms of recognition of online dispute resolution. So that's the blessing of courts, and we've had senior judges of the Supreme Court also talk about taking the process, and an ODR is really the buzzword now. I think if you have trained parties, all stakeholders need to be trained, and we are continuing to struggle when we litigate today, even with how our courts are trying to come up to speed with technology. They are just being thrown at the deep end, and they're struggling with both in terms of how to share documents, how to examine people. But I think if you have actually everybody who's trained, there is, sky's the limit. And I was talking to a general counsel of a large pharma company, and who they deal with a lot of small vendors across the country. They're saying, earlier they were accused that I have to travel all the way to Bombay to, decide a dispute. Now everybody's phone is enough. And they can, work with lawyers in any part of the country. Nobody has to travel. So there's a great saving of expense. And at the same time, there is no feeling of, I have to come to your place, because obviously the dispute resolution would have been a contract that was one-sided in suggesting with the bigger player. So, all of these make a difference in bringing dispute resolution closer. Of course, there should be no way that anybody should feel that this is weighing in favor of somebody else more. I think that a level playing field should be a conscious decision and available. If that is created, there's enough training, and there's now so much technology available to share documents, things like that. So I think sky's the limit. It shouldn't stop just because the pandemic is behind us.
Sure. Just to draw an analogy from what is happening in the education space, I suppose once the digital divide is bridged, probably any online process will be much more will be seen as much more egalitarian and accessible to everyone rather than to a select few. So I'm so happy that we have engaged in such a productive fashion. I never noticed the time pass. We are already nearing the 1 hour mark. So any other questions, please, you're welcome to ask. Otherwise, I shall move on to a couple of concluding remarks. And by the way, you can always reach us at our email address, info@adressnow.com. Please feel free to visit our website and know more about what we do in case you haven't done that already. And we would like to keep in touch with you. Poornima has already sown the seed of probably the next theme, which is the dilemma between place, venue, and site, and how that will probably impact online dispute resolution. We could probably have a separate discussion on that. So unless anybody has any questions, I would like to thank all of you for making it convenient to attend this session. A recording of this session will be available for offline viewing as well. Thank you very much, Prashant. Thank you, Poornima. It was a pleasure having both of you. I'm sure you will grace our events in the future. So I'm putting you both on notice, and I will certainly trouble both of you.
To conclude, Karthik, I would only say, answering your discussion today, the time has come for arbitrators to move on to learn the skills of mediation and conciliation. The way mediation is going now, it is time all of us hone up our skill and learn the skills of mediation and convert ourselves or adapt ourselves to mediation also.
Yeah, that's a very timely advice, Prashant. That's very timely. Thank you. Thank you very much, all of you. Thank you. Good evening.
Thank you. It's been a pleasure. Thank you. Good evening.